For those of you who don't know me, my name is Patrick McQueen. I'm a real estate attorney here in Arizona. I've been doing this 17 years now. We handle all sorts of real estate matters, real estate litigation, real estate transactional matters, both on the commercial and on the residential side. Before I get into sort of the big picture cases that came down in 2020, I do want to mention a couple of key hot topics that we're still encountering, and these are going to play into those cases as well, and you'll see what I mean in a second. But first big hot topic right now is the commercial real estate world in general. It's in a tough spot. I did a tabulation, I did a calculation. In 2020 alone, our firm handled 81 lease amendments or lease terminations dealing with COVID-19, okay? Contrast that with 2019, our firm handled 29 commercial lease amendments or terminations. And so it was a fourfold increase. And it was just in 9 months that there was that big of an increase. And so we're still seeing a lot of commercial real estate folks who aren't feeling real confident. You know, I don't know if the other thing was that a lot of people had a New Year's resolution for 2021, but we've received a number of calls already in 2021 saying, hey, can I get out of my commercial lease? I'm not willing, I'm not able to continue to do this. And so what is it going to take to get me out of my lease? And we'll talk about some of those legal defenses, legal arguments that you can raise, because those are part of the cases that came down in 2020 and are going to continue to come down in 2021. So hot topic number one is the commercial real estate world, as you likely know. Is in some difficult spots or opportunities, I would say. The second big issue is the residential eviction area. Some of you may represent multifamily owners. Some of you may do some commercial property management or multifamily property management. And you know, we're in a world of difficulty if you're on the landlord side. And what started out as the CARES Act prohibited a landlord from evicting a tenant or charging a late fee based on the non-payment of rent. That's expired. We then had Governor Ducey's executive orders in 2020. What Governor Ducey did when it came to landlord-tenant relationship was not create a moratorium. A lot of people thought he had a moratorium, but it really wasn't a moratorium. It was basically, you could still evict, you could get a judgment of eviction, but you just couldn't actually physically remove somebody from the property if they were able to come up with one of 6 or so COVID-based defenses. Those have gone away. Those executive orders have gone away. So the CARES Act is gone. Executive orders are gone. We have some procedural rules that attorneys have to follow, or if you're doing your own eviction, you have to follow. That's not a huge deal for most of us. But now the biggest impediment for landlords, whether it's multifamily, whether it's single family, is the CDC Act. The CDC came out in September and created an act that sort of broadly defined who they were protecting. And the goal was to protect people from eviction. And so the CDC actually has their own moratorium out there. And that expires at the end of this month. So the CDC moratorium on evictions expires at the end of this month. But guess what? It's likely going to be extended. We're 2 weeks away, and we've got a new president coming in, and likely that'll be extended. And what the CDC Act, or it'll be extended in a different way. It'll be a new act or something else. That's kind of what we're predicting. The act, what the CDC Act does is it broadly defines covered persons. So the CARES Act, remember, that came out in March, at the end of March, covered certain types of dwellings. So if you were a landlord and you had a multifamily building or a single family home that was a government-backed or government-secured or insured loan, well, then you couldn't evict. Well, what the CDC has done is they've taken it up a notch and have said, we're covering covered persons, okay? And a covered person, all you have to do to be a covered person, so it's a much broader suite that the CDC has done. To be a covered person, all you have to do is produce and sign a CDC affidavit saying that if you're evicted, you're likely to be homeless, you've taken a job loss, etc. And all you have to do is sign that affidavit, and you can't be evicted, okay? And so it's much, much broader in scope. We don't know, officially if it's going to be extended. We think it's going to be, But a lot of landlords, whether they're multifamily or single family, have said, well, what can I do? I mean, am I stuck? And we're going to talk about some of the constitutional cases that came out that address landlords and what they can do. But from a practical perspective, what landlords are doing, again, whether on the multifamily or single family, they're doing cash for keys, like we saw in 2010 that lenders were doing. We've seen requests for other forms of payment. We've seen gift cards. We've seen tenants doing work at these multifamily apartment complexes. We've seen guarantees and promissory notes signed by family members. We've seen situations where people will voluntarily relocate themselves and say, look, I can't pay rent for this nicer penthouse type apartment, but I can if you want to move me to a different one of your complexes, then that's fine too. But what the biggest thing that folks are doing is they're evicting for non-monetary reasons. They're evicting for pets, unlawful pets. They're evicting for damages, or they're evicting for unauthorized occupants. So there are things that landlords, whether they're multifamily landlords, whether they're single family landlords, can do to feel a little less bound to the CDC moratorium. So those are the two big things that we're seeing, and those are going to continue to spill into 2021. Again, it's the commercial amendments. Commercial leasing world is interesting right now, and then the residential leasing world is rather interesting right now. But I want to go over what we're here to talk about, and we're here to talk about the three most important cases or so, or topics of cases, I should say, or I should clarify, that we saw in 2020, and we're going to talk about how those apply now and how those might affect us going forward. And I've broken the three types of cases. There's not one particular case that just is huge, or there's not two particular types of cases that are huge, but they're sort of lumped into different types of cases. And the way or different types of topics, the way I've sort of lumped these is the force majeure cases, or the defenses to commercial rent payments or other real estate payments. Then the second grouping, or second topic, are the insurance cases. And then the third are the constitutional cases. And all of these cases have effects on your clients. They have effects on my clients. And so what we're going to do at the end is talk about, maybe we'll do a little question and answer session, but we'll also talk about some tips to make sure that your folks are up on these laws, and that you can help in drafting different types of contracts for them. Okay. So the first type of case are these force majeure cases. And this was the big buzz that everybody was talking about in March and April. Force majeure. What does force majeure mean? Force majeure refers to an act of God. Force majeure refers to something so unpredictable that it allows me to get out of my contract, or to get out of having to pay something for a certain amount of time. Okay. And what we've determined is that we've got some analysis from these cases that have come forward from all over the United States, from the federal courts, from courts in other states. We don't have a lot in Arizona, but we expect that there will be some more in Arizona coming. There'll be some rulings coming. And what the Arizona courts will do is they'll look to states, other states, to use for their analysis. So the courts in Arizona are allowed to sort of copy what the other states are doing. And so these cases are considered persuasive. They're considered persuasive authority for the courts in Arizona. So what we've seen are a lot of cases in California, a lot of cases in New York, and a lot of cases in New Jersey. And when we talk about a force majeure situation, we're talking about those situations in which somebody says, hey, the government has shut me down, or hey, my business requires a lot of people to interact, and we just can't have that now because of social distancing and those sorts of things. And so, I don't have to pay rent because of this, or I don't have to continue on the contract because of this shutdown. And so the first part of the analysis that we look at is whether there's a force majeure provision in the contract at all. Okay, whether there's a force majeure provision in the purchase and sale agreement, whether there's a force majeure clause in the management agreement, whether there's a force majeure provision in the lease. Okay, and what courts have said thus far is that if there is no force majeure provision, we're not going to imply one. And that's very important, because a lot of people out there say, well, this is an event of force majeure. This is an event of force majeure. I don't have to pay rent. Well, no, the courts are saying, look at your contract first. If there's nothing in there, if there is no force majeure clause or section in your contract, you don't get force majeure. Force majeure does not apply to you. So the first step in any of this analysis is to look at the contract itself and see if there is a force majeure provision. So we have cases in California, New York, and New Jersey thus far saying we're not going to imply a force majeure provision. You do not automatically get to rely on force majeure rights. So guess what? If you're drafting a contract now and force majeure is important, make sure it's in the contract. Okay, so the second part of the analysis. So first part is there even a force majeure provision? If not, you're out of luck. You're looking at some other defenses that you're going to have to consider making these requests of the landlord. So first we look at to see if there is that force majeure provision. If there is a force majeure provision, the second question has become for these courts, well, does the existence of a pandemic or a declared pandemic or COVID-19 or the government shutdowns constitute an event of force majeure? So the force majeure provision in most contracts says something to the effect of, if there are riots, if there are labor shortages, if there are material shortages, if there are government shutdowns, whatever it is, then force majeure applies and certain things will happen. Well, nobody really addressed a pandemic and nobody really addressed a government shutdown or a stay-at-home order, okay? And so the question becomes, well, does a pandemic in and of itself constitute an event of force majeure? And so what you've had to do is look at different words in each of these force majeure clauses to make sure or to determine if these are events of force majeure. And in most cases, the courts have said, yes, what we had was an event of force majeure. And so we have court rulings that say COVID-19 is a natural disaster. One of the provisions in a force majeure clause is if there's a natural disaster, then certain things happen. Well, guess what? The courts have said COVID-19 is a natural disaster, triggering the force majeure clause, all right? When we think of natural disasters, though, we usually think of tornadoes, hurricanes, snowstorms, whatever it is. But courts have been willing to broaden the scope of force majeure to mean that COVID-19 is a natural disaster. That one surprised me a little bit. We've also had rulings that say COVID-19 was ruled an act of God. Interesting one there too. Therefore, because COVID-19 is an act of God, the force majeure provision is triggered, allowing the parties to do whatever the force majeure clause says. An act of God, the sort of definition of act of God usually refers to someone being sick, an illness, something that is unpredictable. And so that one, I kind of went back and forth as to how that court was going to rule in that particular one. I thought there were easier ways to get to rule that a force majeure event existed than to say it was an act of God, but the court said it was an act of God. COVID-19 has been ruled a casualty triggering the force majeure provision. Okay, so remember, we're looking at a force majeure clause that exists in a lease, in a contract, and what has happened thus far is that nobody has ever really defined, nobody's ever put a force majeure constitute, or the pandemic constitutes an event of force majeure, or a government shutdown constitutes an event of force majeure. So we're looking at other ways in which we can call something an event of force majeure. And again, what's happened so far is that the courts have said, well, a natural disaster, if you get the words natural disaster in your force majeure provision, guess what? You get to use your force majeure provision. If you have the words act of God in your force majeure provision, guess what? That triggers the clause. If you have the word casualty in your force majeure provision, guess what? It triggers an event, a force majeure event, and you can use the clause to your favor. Government actions in limiting businesses or shutting down constitutes government action such that the force majeure provision is governed as well. So if there is a force majeure provision, most courts have been extremely willing to define what happened in 2020 as an event of force majeure, whether they're defining the virus itself as an event, whether they're defining the government shutdown as the event that triggers it. Most folks have been able to utilize the force majeure provision if they have one, okay? Well, let's say that a force majeure provision exists and it's triggered based on what happened last year. Well, what happens next? Do I automatically get out of my lease obligation? Do I automatically get to pay reduced rent? Well, number one, courts prefer that you look to the clause itself. The courts are not usually going to interpret or go beyond the written language that's in your force majeure provision. And so the courts will likely say, what does your clause say? What happens? Are you allowed to stop making rent payments? Are you allowed to postpone the transaction? What are you allowed to do? We're going to the best extent possible, stick to the exact language that the parties agreed to beforehand when they sign this contract, when they sign this lease, okay? But what if there's silence? What if there's something, what if it's not stated what happens if there is an event of force majeure? We've got some interesting cases here, and they're very supportive of tenants. So let's assume again that there's a force majeure clause, but let's say that it's silent as to what happens for a commercial tenant, like a commercial restaurant. Well, in the restaurant context, courts have ruled that the tenants were entitled to pay partial rent, okay? There's a case out of Illinois that probably will be persuasive here in Arizona. And it basically says, look, all you could do was utilize the takeout or the carryout. You couldn't do in-person dining. And therefore, you get to reduce the amount of rent that you had to pay. And therefore, if you already paid full rent for that particular month, you get to go back to your landlord and ask him for a refund. And so the courts have said that in a couple of different places now. And so that'll be an interesting, once people start to get to know about these rulings, they're going to be going to their landlords and saying, hey, give me my money back for at least a couple of months here. And so that was a pretty big ruling that basically said, look, you get to prorate. Okay, if it's silent, you get to prorate. The same thing happened in the retail concept. Remember that Gap, Abercrombie, a couple of other big retailers were closed down. The malls were closed down. They couldn't do anything. This is largely in other states. And they basically said, look, we couldn't do anything. Therefore, we get, for those limited things that we could do during that time, we get to prorate. We get a refund from our landlord. And the courts have said, yes, that's correct. So that's an interesting one. So again, the analysis for the force majeure cases is, number one, is there a force majeure provision at all? If there is not, we have to look at other arguments. Courts are not willing to impose force majeure obligations. There's no implied force majeure, okay? If there is a force majeure provision, well, guess what? Pandemics, government shutdowns usually constitute an event of force majeure, whether you're arguing that it was a natural disaster, an act of God, a casualty. Most courts are willing to give broad scope to what happened last year and say, yes, that was an event of force majeure. Okay, so let's say you have a force majeure provision. Let's say the events of last year constitute a force majeure event. Well, then what happens? Do I have to pay rent? Do I not have to pay rent? Well, then you look at the contract itself. If the contract says you didn't have to pay rent, then you didn't have to pay rent and you shouldn't have paid rent and you can get your money back. But if the contract is silent, what courts are doing, they're allowing for this proration of past rents. And so we haven't seen a whole big uptick of tenants saying, hey, I never had to pay that rent in the first place, give me my money back. But that could be happening. We've seen Gap, we've seen Abercrombie, we've seen some of the other bigger retailers starting to do that from some of the bigger landlord groups throughout the US. So I find that to be an interesting, and we'll start seeing these other patterns develop, but I think right now that's exactly where we're at. So that's the analysis on the force majeure cases. That's huge. If you represent a tenant group, if you represent a landlord group, your tenants now have certain rights to have called back some of the rent. Landlords, may be stuck with having to pay back some rent or give some credits in the future. Okay. So let's say, though, that the force majeure provision doesn't exist in my lease, but I experienced, all of this hardship last year. I couldn't open my restaurant. I couldn't open my retail store. I couldn't open my office, whatever it is. Well, what are the other arguments that might apply? Well, guess what? There's a couple. One of which is called impossibility. So legal impossibility is a situation in which you're claiming that you didn't have to pay rent, or you never should have had to pay rent in the first place because it was impossible for you to even get into your office, for you to even operate your business. And most courts thus far have said, no, that doesn't work. So the doctrine of impossibility is really not there. It doesn't exist. the courts have basically said the subject matter of the contract, whether it's a retail business, whether it's the building, whatever it is, that has to be gone. Okay, so if the government came out in 2020 and said, look, you can no longer operate a real estate brokerage, well, that's impossibility. Or this building is condemned forever because there's COVID-19 in there or whatever it is, that's impossibility. But we didn't have that, and so the court's basically saying, look, don't come to us with this impossibility defense. So what is another alternative? Well, another alternative is impracticability or frustration of purpose. What happened last year was we created an impracticability situation, or my business activities were so frustrated that I shouldn't have had to pay rent at all. And the courts are saying, no, not so much there either. Okay, impracticability really, doesn't work if your building was allowed to be opened at all, or even partially opened. You can't argue impracticability thus far. And so, it's just not working. So impracticability might work in some contexts, maybe in the restaurant context to allow you to pay a portion of the rent. But in most contexts, the courts are saying that one doesn't work either. The third one is co-tenancy. Okay, this one is starting to work, and this one has a lot of landlords pretty worried. Okay, co-tenancy refers to a situation usually in a retail mall context where you have a big anchor tenant. So you say you have JCPenney's or Nordstrom's or Dillard's or whatever it is, and I go into this mall or I go into this area because I know that there's going to be a lot of foot traffic because of Dillard's or JCPenney's or whatever, and now Dillard's and JCPenney's or Nordstrom's or whatever are gone. And so I have this argument that says, well, the whole basis for me to even go into this mall or to go into the strip mall or to go wherever was because that main business was there. That big anchor tenant was there. Another example, I own a restaurant, small restaurant, but all we do is cook organic. And guess what? The organic store that I bought from was right next door, and now they're gone. Well, guess what? That may be a co-tenancy issue. I may no longer have to pay rent. I may no longer have to continue here. Landlords are very concerned with rulings in the co-tenancy situation because that will create this major downfall of malls, of strip malls, et cetera. Because if one party wins and one party says, hey, I've got this successful co-tenancy argument, I don't have to pay rent anymore. I never had to pay rent in the first place. Guess what? It's going to have a little bit of a domino effect. So the first category of cases that we've really seen a lot of impact for the real estate world, it's not one case in particular. It's this sort of cumulative set of cases are the force majeure cases. And again, I gave you the analysis for force majeure. It's changing constantly, but that's the analysis as of today. I also gave you a few of these other arguments that you can use if or your tenants can use or your clients can use if it applies. Okay, so we have force majeure, impossibility, impracticability, and then this co-tenancy. These are the ones that are semi-successful and that landlords need to be a little bit more mindful of. Maybe if they get a tenant that starts asking for refunds, that may happen. Okay, so the force majeure cases, they're out there right now. We don't have a lot of them in Arizona right now, but because Arizona courts are pretty far behind. But I suspect that Arizona courts will start to adopt what the other cases or what the other courts in other jurisdictions have done thus far. Okay, second set of cases is an interesting one as well, and it may affect the businesses that you represent. Okay, I found this one to be fascinating because at the beginning in March and April, I said no way that there's going to be insurance coverage for COVID-19 or business interruption insurance for COVID-19. And the idea was that, if you have a business interruption insurance, which a lot of folks have, how does you usually have to show a sort of physical loss or some sort of casualty event to trigger this business interruption insurance. And a lot of the big insurers were coming out in April and May saying, nope, there is no coverage here because there's no physical loss, there's no physical harm, there's no physical damage to the premises triggering the business interruption insurance. Well, guess what? Not so fast here. There's been some cases, not in Arizona, but elsewhere, where hair salon owners have argued that COVID-19 is a physical substance that led to a business loss. Okay, so basically they argue, this was an interesting one, and it won. They basically said COVID-19 is a physical substance. The physical substance attaches to surfaces, and the loss associated with this physical attachment or this physical virus, however you want to define it, the loss occurred when the government then came in and shut down our businesses. So we have a physical substance triggering a shutdown, triggering a loss, and a physical loss may occur when property is uninhabitable or uninsurable or unsafe. Okay. And by rendering businesses or buildings unsafe, the government shutdown triggered business interruption insurance. I find that to be a pretty lengthy way to get there, but basically what the courts are saying is, look, you may very well have business interruption insurance if your business suffered a loss last year. Okay. Pretty fascinating stuff on that one, because a lot of the experts out there were saying, no way, this is not the type of insurance case. This isn't even an insurable issue. But now the courts have said, yeah, it may very well be. Okay. So first set of cases that have really started coming down are the force majeure cases. Second set are these insurance cases, and the insurance industry is certainly fighting those because it's a unique situation. And then the third were these constitutional cases. And as a real estate attorney, we don't get to see a lot of constitutional cases. It just doesn't happen. And so the constitutional cases arose in almost every single state. And in Arizona, the gym owners and the restaurant owners and the bar owners were the ones who brought the majority of the constitutional cases. There were executive orders that came out shutting down business owners, gyms, bars, restaurants, and those were the ones that were hit the hardest. They still remain the ones that have been hit the hardest. And so the gyms and the restaurants and the bars came up with 3 ways to fight those executive orders to stop the businesses. Okay. They first argued that they're entitled to procedural due process. So you cannot take my right to operate a business. This is our argument. You cannot take away my right to operate a business unless you give me some sort of procedure where I can tell you that everything I'm doing is okay. And the court said, nope. We gave you a right. The gym owners had a right, but it was a post deprivation right. Therefore, there was no procedural due process issue. Okay. So then the gym said, well, okay, we're entitled to substantive due process under the Arizona Constitution and under the United States Constitution. And they basically said that the substance of the laws were flawed. And they said, well, there's no evidence that gyms or restaurants or bars spread coronavirus any more than any other business. But the court said all that the government needed to have in those particular instances was a rational basis for enacting the laws. The rational basis was the protection of the public. Sorry, gym owners, sorry, restaurant owners, substantive due process doesn't work. So then the argument became, well, you're treating gyms, you're treating restaurants, you're treating bars different than you're treating other businesses. So you're violating my equal protection rights under the Arizona Constitution, under the US Constitution. And the courts once again said, well, as long as there's a rational basis, which is protecting the people, guess what? Equal protection rights go out the door. So those guys were kind of out of luck. Now, there are some constitutional cases that are continuing, and these ones relate to real estate. Okay. What we're seeing continuing are landlord groups, largely multifamily landlord groups, who have sued the government and basically say, look, you are taking our rental rights, our rental properties, and essentially giving them to the public without compensating us. By virtue of the CDC moratorium that says I can't evict a non-paying tenant, by virtue of the CARES Act, by virtue of any state executive order, you've taken my property right without compensating me. And under the Constitution, if you take something, you usually have to give something in return. You have to compensate something. So if I take your land to put in a highway, I have to compensate you, fair compensation for this. Well, guess what? There wasn't a compensation structure set up for these folks. That's what their argument is. And those cases have actually survived. So we have a couple in Arizona that are continuing. We have a couple out of state. Those would be the constitutional cases that continue that I find to be rather fascinating. The fourth set of cases that's not listed on here are the ones versus property managers. I've now seen 4 against multifamily property managers and a couple of commercial property managers. And they basically said, look, I went into your building. I was in the apartment complex, whatever it is. I caught the virus. Now you have to pay for my healthcare, my treatment, etc., my pain and suffering. I thought those cases would be dismissed like that. I thought that there was no way to prove or to show that there's causation there. And the courts have said, no, we're going to allow these cases to continue. So the biggest sets of cases that we saw in 2020 that are going to have some application in 2021, those force majeure cases, the insurance cases, the constitutional cases, and I think some of these property management cases are going to continue. So I'll give you a couple of tips. Tip number 1, it addresses the force majeure issue. Put force majeure in writing now. Address how you want it to apply for all future contracts. Particularly if you represent a tenant, you're going to want to say in the lease, a pandemic constitutes an event of force majeure. So you don't have to go to court to prove that. This is what happens if there is a pandemic declared, or a state of emergency declared, or a government shutdown declared. This is what has to happen. I have to pay my CAM charges, but guess what? My actual base rent is abated, or whatever it is. You need to start addressing that in your contracts now. Second is on the insurance cases, don't just let your insurance agent tell you that you have no coverage. And that, because that's what largely happened is a lot of these insurance companies would say, or insurance agents say, no, this isn't a covered loss. This isn't an event that allows you to have business interruption insurance. But guess what? They're wrong. So don't just let your agent tell you that you have no coverage. For the constitutional cases, it's sort of know your rights. Understand the laws so that you can possibly guard against it happening if there is another government shutdown. And those are the tough ones. If you're a landlord, there are some workarounds that I mentioned right when we were first starting this webinar this morning. Evict for other reasons. There are things you can do as a landlord. So those constitutional cases are largely broken down into gym, restaurant, bar owners, and the landlords who have these active cases going on. But there are other remedies for landlords, so keep that in mind. And then for the property management cases, if you don't have protocols in place, if you don't have hand sanitizing stations or cleaning protocols in place, you should get those in place now, because again, those cases are actually continuing. And I was surprised to learn that. So anyway, hopefully that's of some help to you guys. I do have a master sort of spreadsheet. You're welcome to it. It's got a list of where all of these cases are headed and the next steps in the cases and kind of the snippets that people need to know from the various cases that might be helpful. I'm gonna, if you need them, you can email me for those. I've got the analysis. Happy to answer any questions that anybody has as well. So I'll stop sharing this now and open up to some questions if anybody has any.
Patrick, I do have a question regarding the force majeure. It seems like what I'm connecting here is that if you're a landlord, you almost don't want it in the lease contract.
Yeah, probably. I think that's a fair conclusion. What most landlords, the more sophisticated landlords we see are doing, they're basically saying, look, force majeure, constitutes X, Y, and Z, or X, Y, and Z constitutes an event of force majeure. But guess what? You still have to pay rent, irrespective of any of these events. And so the landlords might want to protect themselves as well. And so what they're doing is they're kind of having their cake and eating it too. yes, Mr. or Mrs. Tenant, we're happy to put in a force majeure provision for you. And here are the events of force majeure. But guess what? You still have to pay rent. And so what that ultimately does is it actually protects a landlord. If the landlord can't perform under the contract, the landlord doesn't have these obligations, but the tenant's obligations remain. And so it's so either don't include it if you're a landlord, or include it, but make the obligation to continue to pay rent.
Yeah. Well, and just an editorial comment here. We know that restaurants, mom and pop restaurants, certainly have a tough hill to climb in a normal market, and then to see what's happening to them now, I can see where the landlord would certainly, because I've been a commercial broker, you certainly want to be able to still collect your rent, but there's only so much. Only so much you can get out of a turnip. So eventually they're just going to go away. So yeah, tough situation.
The restaurant, this has been the scariest one that I've seen. And, frankly, I've seen, I was practicing in 2008, 2009, 2010. And I think that the landlords now are a little friendlier than they were in the 2007 through 2010. They're more understanding of what's going on. And so we do see some accommodations that I frankly didn't expect. And so we see some that'll say, look, don't pay me for the next 3 months, pay the CAM charges so we can, continue to pay for the landscaping and those types of things. But they get it, and they don't want to lose the tenants, particularly the mom and pop restaurants, because they do add a lot. But it is a sad situation. I've just seen people just so incredibly frustrated. But I've seen a lot of sort of coming together by landlords and tenants that I didn't quite expect.
Yeah. How about, I know the focus is commercial here, but do you have suggestions or just a couple brief comments about landlords and that own a duplex or a fourplex, how they can try and survive, because they still have to pay their debt service as well in most cases.
Yeah, I mean, that's the tough part, and so I've got a list of about 6 or 7 suggestions, and they're all ugly suggestions. I mean, here's the deal: you can evict until or unless somebody comes up with that CDC affidavit that they sign that says, look, I've got all these situations. The frustrating part for a lot of people is that there's the perception that the tenants are lying, or hey, look, how is this possible? This lease application that I got 6 months ago says that you were making $150,000 a year. You were a great tenant. And now you're telling me you're destitute and likely to be homeless if I continue with my eviction action. And so, but the CDC moratorium doesn't allow you to attack the affidavit. So basically, you can't look at the lease application and say you made $150,000 just 6 months ago, now you're broke, according to your affidavit. I can't do anything about that. I can't, I can contact the FBI because you're signing a false affidavit under oath, but they're not going to do anything about this one-off tenant. So it is very frustrating that you can't, because I've had clients who have said, I'm going to attack the affidavit because I think the affidavit is fake. I think they're lying under this affidavit, and the courts have said, nope, you can't even do that. And so that's been frustrating. And so it's like, well, I have to come up with other reasons to evict. And so we see some quite aggressive either property managers or owners who will go in, once a week and do an inspection to see if there are new pets, or to see if there are new people, or to see if there's property damage, in the hopes that they can ding them for something and get them out. So it is tough. The cash for keys is working for some folks. I've literally seen or heard of stories where they want me to approve a contract where there's a landlord and the tenant can't pay the rent, and so the tenant's doing odd jobs around the duplex. So it's just quite interesting. I've seen gift cards. Hey, I don't have the rent. I don't have the rent to pay you. So here's a bunch of gift cards that I got for Christmas. So it's crazy. And, you know, my suspicion is that the CDC moratorium or something like it will continue. Well, if there aren't any other questions, you're more than welcome, guys, to shoot me. Looks like Sean had a question. Oh, he's just waving. he's saying bye. All right, guys. So if anybody needs any of the sort of memos on these cases or the status of them, there's going to be more. They're coming. The courts have been extremely slow to resolve a lot of these issues. And if you need any of the analysis that currently exists, I'm happy to get it to you. Hopefully it's helpful.
All right, Patrick, thanks for your time, knowledge, and efforts that you put in to teach this class. It's always very informative and you're very appreciated, so thank you.
My pleasure, guys. Happy New Year, everybody.
All right,
Thank you.
thanks.
You too.
Bye, you guys.